Well, it's good to be settled in just in time for Kyle's motions hearing. I wouldn't want to miss this for the world. Another chance for Binger to make a fool of himself, and he didn't disappoint. Hello out there. I am trying to get through. All right, here we go. Old Thomas Clare Binger is going to match lawyer skills against those two dudes. Oh, it's going to be bad, too. And by bad, I mean good.
Mr. Binger, have you got anything?
Judge, I just want to confirm with regard to the Victims' Rights Act, I know Ms. Motley was going to appear representing Mr. Grosskreutz.
Oh, boy. Motley is going to be here. She needs to keep her mouth shut because she's a moron.
John Huber, the father Anthony Huber, had been appearing in the past along with attorney Steve Art. I'm not able to see who's on your Zoom connection there, so I just want to make sure that we have everybody that needs to be here.
Yeah.
I want to see John Huber on the Zoom there so I can see him flip off the judge at the end of the day.
I think Mr. Huber is on. I don't see...
I'm here, yes.
Yeah, and I don't see Attorney Arts and Mr. Grosskreutz.
Nobody could pronounce that poor bastard's name. It's Grosskreutz. And by the way, his own lawyer can't even pronounce it. That's how bad Motley really is.
Is on and Ms. Motley is on. Is there anybody else appearing? Let me make sure that there's nobody in the waiting room.
Your Honor, just for the record, and also appear on behalf of the estate of Joseph Rosenbaum.
A defined estate, I'm sure it is. It must comprise what? Well, let's see. It would normally have at least one plastic bag filled with a bunch of junk, but he threw that away. So I don't know what he has left. Tent? Sleeping bag?
Fair enough. All right, and...
We're not aware of anyone else who would be appearing, Your Honor.
all right, and what else?
Other than that, Your Honor, I don't have anything new since the last filing.
All right, Mr. Richards.
Yeah, I think we're all up to date. Everything was filed.
Okay. All right, why don't we take the motions up and then we'll talk about the progress of the case. The first one that I looked at and it was received on in the first batch was a state's motion for other acts evidence. The state alleging that on June 1st of last year, the defendant assaulted a female in Kenosha.
Oh, heavens. He got into a fight with a female. Oh, my gosh. When the jury sees that woman beater, they're going to convict him. And that's what everybody's been saying on Twitter and on Facebook and on YouTube. You wait until the jury sees him punching a female. Oh, yeah? Well, that's the reason why that shit's going to get dismissed, thrown out, because it's prejudicial.
And I did review your briefs. Did you want to add anything to what's already in the brief, Mr. Binger?
Your Honor, I've reviewed the defense response brief, and I think that there is a notion that the defendant's state of mind is not relevant here, or that because there's really no dispute that these were intentional acts, that somehow the only issue remaining for trial is the reasonableness of the defendant's actions. That may very well be where we're at the end of the trial, but at the beginning of the trial, I have a burden of proof. There are claims against the defendant that go to his state of mind in terms of intent or recklessness, and it's my burden to prove that. At that time in the case, I won't have any testimony from the defendant. I don't know if he's going to testify or not. He doesn't have to. He has the right to remain silent. So I certainly can't presume what evidence may or may not come in the defense case. This is an unusual homicide case in the sense that it is not a whodunit. This is not a question of did the defendant kill anyone. The question is what was his state of mind and whether or not his actions were reasonable or not.
What makes that so unusual? It's a self-defense case. In the self-defense case, you typically don't have a whodunit. Why are you claiming this is so unusual? In a self-defense case, it's an affirmative defense. You're admitting that you did the shooting. So every self-defense case has this element where we all know who did the shooting, and yet he's sitting there going, well, now this is really strange. Boy, we haven't seen this kind of case before. Yeah, okay, Binger.
Whether or not they go to intent or recklessness or some other mens rea. That is the mental state that the state needs to prove. We don't convict people without the requisite mens rea. So his state of mind
Oh, I bet you've tried many times. In fact, you're trying to do it now.
is perhaps the most critical issue in this case.
By the way, he throws that, this is critical. This is the most critical aspect of this case. This is so critical. He says it all the time on everything, and he gets all this stuff thrown out. And yet, for some reason, he doesn't dismiss the charges. So how critical could it have been?
Motions that we filed, both this one and the other acts motion that we'll get to in a moment, illuminate the defendant's state of mind, both on the night in question and also on these preceding events of June 1st and August 10th.
No, I would argue that they show the state of mind, and maybe on those nights in which he did them. On August 25th, no, I don't think that you're going to be able to make that claim.
Is the date of the other motion, or the events of the other motion. And I believe that these motions help the jury to understand the defendant's state of mind. And I think that that is a relevant element, both in terms of the criminal charges here and also under State v. Sullivan, in terms of intent, motive, knowledge, absence of mistake, etc. The first motion that you discussed, Judge, has two prongs to it. One is with regard to that June 1st fight. That is a fight which has been captured on video. It is an incident in which it's my understanding that the defendant's sister got into a physical altercation with another female.
Oh, he's admitting that one of those that was in the altercation was the defendant's sister. I wonder if the fact that it's your sister involved in the fight, could that color your state of mind? And then later, when you're involved in an altercation where your sister is not involved, maybe that might change the state of mind for that night.
This was essentially a one-on-one fight, somewhat of a consensual fight. Both of them interested in assaulting one another. But in the midst of that, Mr. Rittenhouse intervenes and begins to add on to what his sister is doing to this other female.
What about what the other female is doing to his sister? I thought you said it was a one-on-one consensual fight, but you're making it look like one person was fighting the other one and not receiving anything in return. Oh, by the way, Kyle stepped in because his sister was involved in a fight. You're lucky that the judge threw this out because, and I said it before in one of my previous videos, that if you got this admitted, you open up the defense to go to that jury and say, yes, he did get involved in a fight because it was his sister. Kyle loved his sister. He was there to defend his sister. He's defending a family member. And all little jury members would have little Kleenex wiping the tears off their faces, thinking, God, what a beautiful boy. Yeah. So in a way, you gained nothing by putting this motion in there. They could have easily have counterattacked on this.
By assaulting that second female. And I think that that goes to the defendant's state of mind in this case because it shows that his understanding of self-defense, his understanding of the need for self-defense is a certain way.
By the way, notice he said female all the time. And in his motion, he said female all the time, 6 or 7 times. And that's the prejudicial nature of his motion. He wants to get this idea across to the jury that Kyle is a woman beater. Now, I know all you anti-Kyles are out there going, yeah. When the jury finds out that Kyle likes to hit women, they're going to convict him. Yeah, for the wrong reasons. The shootings in Kenosha had nothing to do with gender. And you were hoping that the jury would use the idea that Kyle is a woman beater to convict him. Gee, I wonder why this kind of evidence is not admissible. It's for that very reason. And I said it in a previous motion, I'll link it below, that your constant mentioning of female is just displaying to the judge that you really want this in front of the jury to prejudice them against the client as a form of character assassination. if all of the victims in Kenosha were females, and there was a question as to whether Kyle shot them because they were female, then mentioning the fact that Kyle hit a female repeatedly might carry some weight. As it stands, irrelevant, and that's why you're going to lose here. Well, actually, he's going to lose because there are tons of other things that was wrong with your motion, not just that one.
And I think it's an improper and unjustified use of it. I also think it goes to...
Unjustified? How do you know it's unjustified? Do you know what the fight was about? Maybe the fight was about Kyle. Or perhaps Kyle had a good reason to step in there and start swinging at that girl. Perhaps his sister was catching the losing end of it. Whatever, Kyle was never arrested. He was never convicted. You are in no position to claim who was justified and who was unjustified in that fight. All we have is a few second clip of it. We don't really know what it was about. We don't know anything about it, other than the fact that his sister was involved.
What I will posit will be a strong theory of the state's case here, which is the defendant is essentially a teenage vigilante, involving himself in things that don't concern him.
That doesn't concern him? Okay, this is an opening here, I thought, for the defense. They didn't take it. But I think I would have made a little snide comment here and say, hey, Judge, where I'm from, if I have a family member involved in a fight, it concerns me. That's how I was raised. But not Binger. Binger's like, oh, my brother is involved in a fight. That's none of my business. Uh-oh, he's pulling out a knife and he's going to stab my brother. No, that's none of my concern. It doesn't involve me. I better not do anything. That kind of shows you what kind of person Binger is. He doesn't even understand the fact that if you see a family member involved in a fight, you're likely to get involved yourself. And you should.
We have a common theme here, both with regard to this incident and the August 10th incident that's the subject of our second other acts motion. The defendant throwing himself into situations that don't concern him, that he has no complete knowledge of, that no one asked him to be involved in.
I throw myself into situations that I've not been asked to get involved in all the time. I think we all do.
And using force or threatening to use force in an unjustified, illegal, unwarranted manner. So I think with regard to this other acts motion, that June 1st incident illuminates the truth for the jury. It illuminates the defendant's state of mind. And the jury is going to have to consider that state of mind when it makes its determination here in this case.
Yeah, it eliminates the state of mind that night or that day when he was getting involved in the fight. It shows his state of mind. My sister is under attack. I need to defend her. That was his state of mind. What the hell does that have to do with shooting people in a riot?
The second part of that other acts motion is with regard to the incident after a court appearance in January, where the defendant goes to a bar on the scene and is serenaded by members of the Proud Boys. Now, we have since learned that those individuals that were serenading the defendant consist of the highest echelon of the Wisconsin Proud Boys chapter, including their leader, their current sergeant-at-arms, their former sergeant-at-arms, and other high-ranking members of that organization. This was not a random crossing of paths here in a random bar at a random time.
Just because those are high-ranking officials means it can't be random? All right.
They just happen upon one another. This was something that was coordinated. This is something where Mr. Rittenhouse intended to be there. These other individuals intended to be there.
When I go to a bar, I intend to be there. And the other people in the bar, they intend to be there too. I don't think any of us were forced to go there against our will. That doesn't mean we coordinated our appearance. I mean, who buys this? Do you think the judge is falling for this? See, Kyle is there and the Proud Boys are there. They both wanted to be there. Therefore, they must be working in coordination with each other. Yeah, nice logic.
And the Proud Boys organization is relevant to this case because we have to put the incident of August 25th in context.
In other words, we have to layer a whole bunch of bullshit on what took place. That's what he means.
This was not a festival in the park. where somebody suddenly pulled out a gun and started randomly shooting.
Yeah, that would be murder. And you're all but admitting that's not what was happening here. Okay. You're working for the defense here.
Everyone that was there on the streets of Kenosha on August 25th was there because of their beliefs, one way or another, with regards to the shooting of Jacob Blake. And I don't need to argue one side or the other. The court does not even make a determination one side or the other. But we can't ignore the fact that people were drawn to the streets of Kenosha that night because of a response to the shooting of Jacob Blake.
No, you cannot make the claim that everybody there was there because of Jacob Blake. Did you poll everybody? I'd like to see the statistical inferences you're making, even if you did. And there's no evidence whatsoever that Kyle was there because of Jacob Blake. What evidence do you have? So how can you make a claim that everybody was there because of Jacob Blake, and therefore Kyle must have been there because of Jacob Blake, even though there's no evidence to show that he was there because of Jacob Blake?
There were some out there that believed that that shooting was justified. Some felt it was unjustified. There were other chaos tourists like the defendant who were drawn like a moth to the flame to our community. We've seen folks that have committed crimes under the cover of that chaos. Burglaries and looting and arson.
Oh, terrible things. Burglary, looting, arson. That damn Kyle.
The defendant wasn't one of those people, but...
Oh, well, shoot. He wasn't one of those.
This was the type of person that was drawn to our community. The defendant...
What, not a looter? Not an arsonist? Not a rioter? Okay.
I believe, was drawn to this incident because of his beliefs, which are consistent with those of the Proud Boys. And I believe that those beliefs include a desire to use violence to support that philosophy.
Now, if I'm the judge, I come in there and say, you're telling me that you believe that he was there for nefarious reasons. I don't care what you believe. I care about what you can substantiate. You can believe whatever you want. And you can believe that the defendant is guilty. That doesn't mean that we have to convict him just because you believe so. It's not about your belief system. It's about what you can prove.
The Proud Boys are a well-known national organization that takes pride in using violence to achieve their means, that takes pride in showing up at rallies and protests by what they consider to be their opposition, which can be loosely considered to be Black Lives Matter or Antifa or whatever you want to call them, and using violence to disrupt those protests. The defendant came to our community. He's not a resident. He's underage. He's out after curfew. He's armed with an illegal weapon.
Ooh, the judge should have stepped in. That hasn't been determined yet. The judge knows that he has that motion on his desk. The defense filed a motion, and you responded to that motion about whether the whole thing about minor possession was legal or illegal. But now you're claiming that it was illegal? Come on.
Why? That is the question. His state of mind, his intent that night, is a crucial issue in this case.
Okay, but the fist fight that took place 2 months prior and the Pudgy's incident 4 months later doesn't tell us anything about that.
The defense will no doubt try and portray the defendant as an altruistic, young, idealistic individual who was here to try and help our community, protect a business, clean up graffiti, use his medical supplies to help people in need. They will try and show his state of mind as being a positive, helping one. The state is entitled to introduce evidence that further illuminates his state of mind for the jury.
The state is entitled to shit. It's up to the judge to decide. But notice something, the difference here. You're right. This defense is going to try to paint Kyle as a good dude, one who was out there helping people, bandaging wounds, looking for injured, protecting property, overall being a kind of a nice kid. And guess what they're going to use for evidence? Stuff they collect that night. Video recordings of the defendant that night. What do you have? Something that happened 2 months prior, something that happened 4 months later. Do you not see the difference between those two types of evidence?
And the jury will ultimately make the decision as to his intent, his motives, his state of mind, what he personally believed at the time of these shootings, and they will introduce their reasonable impressions as our community members as to what a reasonable person would do in those circumstances. So those are the questions the jury is going to be asked. I believe a jury's trial is about the truth. I believe that these issues go to the truth of the matter. The jury can be advised as to how to consider the weight of this evidence. The jury can make its determination as to the weight and the relevance, the importance of, or the pertinence of this in terms of whether it's really a true description of the defendant's state of mind or whether the other side, portraying him in a different light, is the true portrait of his state of mind.
If that was true, then why don't we just admit everything? I mean, if the jury is going to be able to make that deduction about what his true state of mind is, if we just give them everything, then why do we even have this admissibility argument in the first place? And the answer is because of the nature of prejudicial. It is not true that the jury can weigh these things and determine the true state of mind. They're human beings. They have failings. And when they see Kyle hitting a girl, they're likely to form a negative image of him and try to convict him of something that's completely unrelated. That's why we have the Sullivan test. That's why we have an admissibility issue here. Your argument is, let's just show them everything that I want them to see, and then you can tell the jury what they should ignore. Now, that's not to say that the judge once in a while will tell a jury, look, what you see on film there, you are to ignore a certain aspect of it because that's prejudicial. But those instances, the prejudicial evidence is sort of unavoidable. There was no way to present the evidence without the jury seeing the other thing. Here is not the case. You're basically making the argument, let's just give the jury the stuff and then let them decide what's important, what's not. No. The judge decides, not them.
But I believe the state is entitled to introduce these two pieces of evidence as part of our first other act motion because it goes directly to these issues. Looking at the Sullivan factors.
The state is not entitled. Again, the judge decides.
These are being sought to be admitted for a proper purpose. They are relevant to the issues at the trial, and they are not unduly prejudicial. They are close in time. They are directly relevant to the factors in this case. The court can give a limiting instruction as to the use of this evidence, which will also help to mitigate any undue prejudice here.
You said it wasn't prejudicial, but you're saying now the judge can tell them not to be swayed by it. It's prejudicial. Look, if you show the defendant hitting a girl, how are you going to instruct the jury to ignore that? Pretend you didn't see it.
But again, these are the defendant's own actions. He's responsible for his actions. What he did on June 1st, what he did at the bar in January and scene, and of course, what happened on August 25th here.
Yes, he's responsible for his actions. He's responsible for what happened in the fight. He's responsible for what happened at Pudgy's. He's responsible for what happened in Kenosha, at least for the things that he can be blamed for. But that doesn't mean that they're connected.
So for all those reasons, Your Honor, I believe that the court should grant our first other acts motion and allow the state to introduce these pieces of evidence as part of our case in chief. Thank you.
Now it's time to wake up the judge. Judge Schroeder, wake up. Is he done yet? Yeah, he's finished. Oh, okay. That's what's happening right now. The judge has already read Binger's motion. He's not even listening because his motion was so stupid. Look, I went over it in detail in a previous video, line by line. I read it. It's sophomoric. It looks like it was written by a high schooler. It is horrible. And in fact, just to give you an idea of how bad it was, he cited a whole bunch of web pages to substantiate his arguments. But when you clicked on the links, the web pages didn't say what he was saying they were. And it finally dawned on me that the way he did his research for his motion was he just typed in Proud Boys violence and he just copied the links as they showed up in the search engine. He didn't read them. And in fact, you may think, well, now wait a minute, now that's a pretty harsh claim. The first one was a link to the Seattle Times, where he claimed that this was an event where the Proud Boys caused violence in Seattle. However, even though it was written in the Seattle Times, it was referring to an event that happened in Florida. He didn't read the webpage. Yeah, that's Binger. That's the motion, the crap that Judge Schroeder had to plow through.
Mr. Richards? Mr. Schroeder? Good, I'm going to address it if I could. Thanks. So as it relates to the first other acts on June 1st, so this...
By the way, before he gets started here, listen how he emphasizes words, especially words like anything, no, not. He's crystal clear. This guy knows how to work a crowd.
State is asking you, or inferring that they're able to ascertain Mr. Rittenhouse's state of mind 2.5 months prior to the incident. So his state of mind on June 1st, and his actions on June 1st somehow play a role in his state of mind on August 25th. This is, as an officer of the court, this is what I'm telling you.
And by the way, why does he say as an officer of the court? He's basically staking his reputation on the line. He's saying, here, what I'm going to say next, I guarantee. And guess what? If I turn out to be lying, I have to face serious consequences for it. And so it's almost like putting yourself under oath in a way.
Rittenhouse will not be debated that this action was intentional. It will not be debated that the action was intentional, and he will raise the issue regarding self-defense. When we're looking at the purpose of other acts...
By the way, yeah, Binger, look over there. That dude's going to eat you for lunch.
Intent is one purpose, and it's a proper purpose. However, intent is normally admitted if it undermines an innocent explanation for the person's behavior. That is not happening here. There is no innocent explanation. There's an explanation, but he fired the firearm intentionally. As it relates to motive.
In other words, if Kyle had fired it accidentally, Binger's argument might make a little bit more sense. Well, I mean, as much sense as Binger could make. In reality here, Kyle meant to shoot the people he aimed at.
If they are trying to establish that he had some motive 2.5 months before, teenagers getting into a fist fight, does that make it more or less probable? Is it a fact of consequence that he was in a fight 2.5 months earlier, that he did not act in self-defense in this case?
By the way, notice he's asking the judge a question. Binger didn't. Binger just rattled off. This guy is asking the judge a question. He's pulling the judge into the argument. He's really good.
Does that make that more or less probable? The answer is it does not. It doesn't have anything to do with whether or not it makes it more or less probable that he acted in self-defense. The entirety of this is captured on video. The only issue in this case is going to be the reasonableness of those actions as they're determined subjectively and then objectively from a reasonable person in his position. So they describe him as being somebody who comes to Kenosha looking for trouble, even though they don't mention he works in Kenosha. He works in Pleasant Prairie. And then his father lives in Kenosha.
Also, his best friend lived there. I wonder why they didn't mention that. And by the way, Kyle, he's thinking, dude, man, I want him speaking to the jury in closing arguments.
And I would submit to you that when you look at the similarities, if we're really going to do a Sullivan analysis, the biggest thing in Sullivan that was different really was the manner and form in which one was a verbal argument, one was an assault. And we have reached a position where teenagers getting into fist fights makes it more probable that a teenager that used a firearm in self-defense. When we have the self-defense on tape, we have the case on tape, I would submit to you it adds nothing to that determination as to whether or not his actions were or were not in self-defense and whether they were or were not reasonable under the circumstances. So where I believe it fails, if you believe it's the proper purpose, it adds nothing to the case as it relates to his state of mind 2.5 months later, and certainly because this isn't a whodunit, and it wasn't an accident. It is an intentional act with an affirmative defense attached to it.
Okay, so notice the pacing. He's taking his time and he emphasizes when he needs to. He is talking to the judge. He is trying to make a connection to the judge. Binger didn't do that. Binger rattled off his arguments to the judge. He was speaking at the judge. This man is speaking to the judge. There is the difference between these two lawyers. This guy is going to absolutely clean up on Binger in closing arguments.
And I don't think under those circumstances, this particular instance has any relevance to that. All right? As it relates to the Proud Boys, I mentioned this in the brief, and Mr. Binger has ignored it. Mr. Binger has ignored it. For this to be considered by you, there must be evidence by a preponderance that on August 25th, 2020, Kyle Rittenhouse was either a member of the Proud Boys or had loyalties to that group. It is no different than you would make a determination if there was, for example, somebody wanted to introduce evidence of a gang membership. I'm telling you as an officer of the court, we have downloaded Mr. Rittenhouse's cellular phone. We have an expert review that phone. That expert has done an analysis to try to determine if there is anything on that phone related to Proud Boys, militia, white nationalists, Boogaloo Boys, KKK, 3%ers, any type of hate group that you might consider. And the finding was the extraction does not establish that the user belonged to or even had any interest in any malicious-style organizations. Mr. Binger has provided you no information whatsoever that on the day in question, August 25th, that Kyle Rittenhouse had any affiliation with that group at all. He's asking that you take and allow evidence to be admitted over 4 months later about a photograph without any information that anything related to this case involved the Proud Boys. There has been nothing. And I have cited for this court cases in my brief related to, for example, gang memberships. And in every one of those cases, the court had to make the finding, first, the person is in fact a member of this organization or has loyalties to that organization. You've heard nothing in his brief and nothing in his argument today that would substantiate that on August 25th, that fact existed. There has been interviews with witnesses, some of whom are admitted militia members, some of whom are admitted far right-wing have right-wing ideology, to a person none of them had ever heard of, talked to, knew of Kyle Rittenhouse prior to that day. None. So there is nothing in this record, and there's nothing that Mr. Binger can point to that should satisfy you to even do this analysis, meaning that there has been a showing by a preponderance that he has any of these affiliations. Okay? So I don't think they get there. However, if you're going to make the considerations as to whether or not they have provided that evidence to you by preponderance.
So what he's saying is, there's no point in even doing a Sullivan analysis. He doesn't have anything. But if you really want to go ahead, waste the time doing it.
And we're going to go to the relevance standard. There is nothing that would indicate that any of these shootings were related to, he describes them as the fraud was as a racist hate group. There is nothing in this evidence that would support the idea that any one of these shootings was racially based. I mean, we have to remember the 3 people that were shot are white. The only racial statements that were made that's going to be in evidence in this case is of Mr. Rosenbaum. The first person was screaming the N-word during this. That's it. So to admit evidence that because he's a member or has ties to an organization which he's been unable to prove, that this somehow is a motive for the shootings, when unless they can tie that these shootings are somehow racially related to these 3 people, it doesn't add anything to whether or not it was done in self-defense. It is without debate, Judge. All 3 of these people were chasing Kyle Rittenhouse. All of them.
All of them. Emphasis.
That is not debatable. So for them to say the fact that he has, or they believe he has some tie to this organization, without any information that in fact that's the reason that this happened, it doesn't move the ball further down in terms of making something more or less probable, a consequence of fact. If they can't show that this shooting was related to that and argue that's the reason it wasn't in self-defense, I don't think they move the ball. And I think if you're really going to do the Sullivan analysis, what they're talking about is 4 months after the fact. People in a bar, there's no information that Mr. Rittenhouse knew who they were when the photos were taken. But he's having lunch and they're taking pictures. That is somehow close in similarity to what happened on August 25th. As I mentioned in my motion, my response, August 25th has been described as a war zone in Kenosha. The evidence in this case will be multiple people are armed, whether it's militia members, rioters, threats are being made amongst the groups, there's a curfew, there's police presence. You're going to use that and say, having lunch and taking photos with people with no tie to that organization is somehow moves the ball toward making it more or less probable this was not done in self-defense. I ask that you consider it, as I said, much like courts consider membership in other organizations. There has to be some tie to it before you would allow it to be admitted. I would finally, in this particular case, talk about the unfair prejudice without a tie to it, without some information that he's part of this group, and without some information that these shootings were motivated by hate or race. It is, the probative value of that is substantially outweighed by its prejudicial value. We are hoping to try this case on facts. And to admit evidence that bears nothing moving forward on the case, other than to say he has some ties to some hate group, even though there's no proof the shooting was related to a hate group, I think would wildly prejudice the jury as it relates to the facts of the case. So I don't believe they, certainly as it relates to the Proud Boys, I don't even think you get to this, Judge, unless Mr. Bringer can point to some indication that on that day there's a connection that he can actually put forth in evidence. But otherwise, I believe the evidence is not relevant. It should not be admitted. The first one is 2.5 months before. The second one is 4 months after. And I don't think it would assist the jury in any way in this case in making that determination. And I would ask that you deny the motion.
Thank you.
So the judge goes, whoa, man. So reasonable. Boy, he pulled me in. He spoke to me. And every word crystal clear, and it all made sense. Okay, Binger, go ahead, lay it on with a trowel. I was like, whoa, my man.
I'll tell you, with respect to both of these requests, I think if I admitted either of these, I'd get reversed. That's the bottom line. I think that the first one, the incident involving the sister, this is clear, in my estimation, it's a propensity evidence. It's an opportunity to suggest to the jurors that he's acted on in a violent way on other occasions, and therefore he acted in a violent way on this occasion. There's no connection between these two events at all.
And this is the argument the anti-Kyles really struggle with. You see them on YouTube in the comment section all over, and they don't understand what the judge is saying here. They think, well, if what he has done in the past indicates he would have done in the future, well, we can use that, right? No. You have to be tried on the evidence of the actual crime itself, not by what you have done in the past. So if you have been caught burglarizing, or you can have a witness go up there and say, yeah, he has burglarized many places, and the guy is being up for burglary, cannot be admitted. This is called propensity evidence. In other words, any evidence that indicates that the true nature of this person is to commit a crime like this. Therefore, he must be guilty. It doesn't work. And Binger has tried really hard to avoid making the evidence look like it's propensity evidence. That's the reason why he's brought up all this thing about state of mind and all that. He's trying to dance around it. The judge's not fooled. He knows that what Binger wants to try to do is say that Kyle is inherently an unstable, dangerous kid. We've seen it in the past. Therefore, he must have been the one that did it that night.
They're totally dislike each other. One involves a fight involving some kids, including the sister of the accused, and how he reacted in that particular instance, which has nothing to do with what happened in an incident which I haven't seen all of the videos that you folks have had or seen witness statements as you have. But it sounds like pretty clearly that at the time that the first incident occurred, and certainly I've seen the videos of the second set of shootings, that in all of the instances there was actually contact between the people leading up to the shooting incidents, and in all of the incidents, there was some confrontative behavior, which is certainly subject to multiple interpretations, and I don't want to get into that, that's for the jury. But it's nothing like the incident involving the sister, so this to me is clearly propensity evidence. It's exactly the kind of evidence that the rule is designed to prohibit.
That's kind of insulting. The judge is basically saying, Binger, your argument is so bad, that's why we have this in the first place. We should call this the Thomas Clare Binger rule from this point on.
And as I say, I'm virtually certain that if I admitted this kind of evidence, it would be a reversal if there were a conviction. You make reference to having a consistent motive. That kind of thing would would be more persuasive if there were similar incidents in which there were demonstrated consistent motive. If the defendant would have gotten up on the top of the high school across the street and every time a person who appeared to be a member of a disagreeing group walk by and take a shot at him, that kind of behavior would be a consistent motive and would be very definitely admissible, but I don't see any connection here at all. So that request is denied. While I agree with you that you have the burden of proof, and you can't, and the defense cannot add off your evidence by saying we're going to acknowledge it was a willful shooting. I agree with you there. I also have to be open to the voice of reason in terms of how the case is shaping up, and I don't think there's any doubt about the fact that the defense is clearly conceding the issue, and the law is also clear that when that's the case, the judge has to look at it a little bit differently. Certainly, if they walk in here on day of trial and start claiming that it was the acts of shooting were not willful, then I'll take another look at this evidence, although I certainly don't want to suggest to you that there might be a different ruling, but it would put a different light on it for sure. So that.
Okay, so what was that about? Well, there is in state law a statement that says that if the prosecution wants to bring in some form of other acts evidence to prove that some crime took place, that you can't prevent them from introducing that evidence simply by admitting that the crime took place. In other words, admitting guilt.
Request is denied. The Proudboys evidence, at this point, I don't know. Perhaps you have other information which I don't know about, but I don't know whether there was a prearrangement to meet these people or if there was an awareness of who these people were. I have to tell you, I never heard of the Proud Boys before this case. And you cited a Seattle newspaper, and I'm not going to rely on a newspaper account about what an organization is, whether they're a hate-inspired group or whatever they may be. There's such a spectrum of groups in this country, and it seems to be more every day. But and I don't think it's for the courts, except in the most appropriate circumstances, to be making determinations, and certainly not on the basis of an article in a newspaper in Seattle, about what an organization is.
Judge, you didn't click on the link, did you? If you'd have clicked on the link, you would have found out that although Binger was claiming that this event showed Proud Boys committing violence in Seattle, actually the link was talking about an event that occurred in Florida. It was just the Seattle Times reporting on it. That's the reason why it's so important. Click on the links, especially when it comes to Binger. I mean, again, and I've said this before many times, that motion that he filed, all the motions that he filed, they come right out of high school. All of the citations from web pages. And they just post the links at the bottom, but click on them. You'll see that the claim that he's making in the body of the motion is not substantiated by what's in the actual web page. In one of my previous videos, I walked right through it. I showed you what the actual web pages said and doesn't match what's in the motion. And essentially, Binger's lying. That's lying. When you say something occurred and you post a link and that link doesn't say that, that's lying. And Binger does it all the time.
But assuming that these people are a known group that is inclined towards violence, and particularly violence of a particular type, again, directed against particular people, there's still no suggestion in the evidence that's been offered to me that this was anything other than a happenstance occurrence. And even if that isn't true, what the scope of the defendant's understanding was, and obviously it is an unfortunate fact that this case has become a surrogate for a lot of emotional reaction that has nothing to do, or little to do, or nothing to do with the issues in the case.
That's right. Meagher's going, yeah, that's exactly what I want. And one of the reasons why this has become a surrogate for all these political arguments, Binger. He's played the propaganda tool pretty effectively, although you don't have to be no rocket scientist to do it. He certainly does it better than he does lawyering.
But if this man is accused of these crimes, which could send him to prison for life, and he encounters some people who embrace him and start to, can we take pictures with you, and somehow make him feel better about himself, and he reacts by smiling with them and taking some pictures, for me to let that in as evidence of a motive that existed 4 months earlier, can't see it.
Look at his facial expressions. He has the look of, you have got to be kidding me. You brought that crap in front of my courthouse? Oh my God.
Absolutely not. Again, I would expect it to be reversed if I did that. I don't know anything about the hand gesture. That's another thing I never heard about before it came up in the context of this case. And I don't know about it, and I sit in the criminal courts all day long, and I deal with a lot of racially charged cases, believe me, and I never heard about this hand gesture, meaning having any, first.
He's doing it. He's calling out all of his white supremacist judge friends. Attack.
The time I saw it, or a version of it, was Chef Boyardee, a can of spaghetti.
We're not alleging Chef Boyardee's a member of the Proud Boys, but
You're getting your ass kicked. Throw a joke out there. Not going to help you.
But 2 things. First of all, this was not a happenstance random meeting. In fact, according to a New Yorker article, which interviewed they interviewed various people involved.
Hold on. Talking to a judge like that? Okay.
And including members of the Rittenhouse family and their supporters. The defendant went to Miami on January 12th of this year and was picked up at the airport by the president of the National Proud Boys organization, who took him out to lunch. That was intentional. So this is consistent, this is a pattern, this is not a random meeting at Pudgy's Bar and Scene. This was January 12th. So this.
In other words, the judge is saying, when was the event? He's thinking August 24th, August 27th? No, it was in January.
9 days or 8 days after the incident at Pudgy's Bar and Scene, the defendant's in Miami, picked up at the airport by the head of the National Proud Boys organization. So I submit to you, the question the defense asks is, what's the proof that he's affiliated with his organization? This is the proof. He goes up.
Hey, Binger, the judge probably read the article too. And the judge, by reading the article, realizes you're full of shit. The article doesn't actually say this. In fact, Paige Williams in the New Yorker article, which I've gone over very thoroughly, I have like 8 videos on it, okay? She does say that Kyle and Wendy seem to be uncomfortable with the appearance of these other people. They didn't know them. In fact, the whole thing was arranged by the lawyer who was representing both. And the lawyer was trying to impress each of the clients. He was trying to impress Kyle and Wendy that he had this top-notch Proud Boy as a client. And he's trying to impress on the Proud Boy that he has famous Kyle Rittenhouse as a client. That's what that was all about. Both of them unwitting players in this lawyer's little game. And so to introduce this in front of the judge who probably knows better, it's not going to play. And besides, you still have the problem where you can't show that Kyle was involved in the Proud Boys that night in Kenosha. That's the problem. So what good does this do?
After court, drives up to Racine and meets them at a bar, goes to Miami, is picked up at the airport, and has lunch with the national head of that. So this is the evidence of the affiliation.
Meeting about August 25th of last year.
And the jury can make a decision on that, Your Honor. I believe that it is consistent with the Proud Boys' mantra, their philosophy of going to these types of protests armed with the intent of causing violence. And I think we will be prepared to introduce testimony from someone who is affiliated with the Proud Boys and will tell the jury about their philosophy, will tell the jury what sort of violent activities they do at these incidents. So again, I understand the court doesn't want to rely on a Seattle newspaper article. We will have a witness who will tell the jury exactly what the Proud Boys is about, exactly what they try and do, exactly what their philosophy is.
No, you won't have the witness.
Will identify the people in these meetings. Okay, so I understand the court may believe that because of prejudicial nature of this, we're not going to introduce the evidence. But I want to button down those two issues. This was not a random chance meeting at Pudgy's pub because of the incident in Miami. And second of all, we will introduce evidence about the Proud Boys, far more than a newspaper article. So,
okay, are you going to introduce evidence that Kyle was a member of the Proud Boys that night? Are you going to present anything like that? There's your big problem. Judge doesn't care if the Proud Boy gets up there and talks about how bad the Proud Boys is. He wants to know, was in fact Kyle a member of the Proud Boys that night in August, or at least had some allegiances to them? In other words, did what he did because of his connection with the Proud Boys. You have no evidence to support that. And until you do, this is all bullshit.
those issues, we can surmount those obstacles to the court's ruling, if that's what the court is concerned about.
All right, let's assume you're bringing in the evidence about Proud Boys being in Kenosha on the day in question, and that they're here for their purposes. Is there any suggestion that they were connected in any way with the accused?
On the day of August 25th, I will acknowledge that I am not going to be able to prove that that was a coordinated thing between the defendant and the Proud Boys that night.
Then shut the hell up. Shut the hell up. Just be quiet. You're embarrassing yourself. Why are you even trying at this point? The defense already put together a very crystal clear argument as to why you have to show that he was a member of the Proud Boys that night, or at least he had some sort of affiliation with them that caused him to do these acts. They made it very clear to the judge. You don't have that evidence. Be quiet. Sit down. Well, you're already sitting down. Why are you doing this?
However, I believe there's a strong inference based on the fact that after court in January, he goes out to Pudgy's, goes down to January or Miami later that month, and meets with not only the head of the Wisconsin Proud Boys, but the head of the National Proud Boys. I think there's an inference to be drawn from that. Now, the jury can be instructed, well, wait to give it. But the defendant's actions of coming into our community illegally after curfew with a gun at the time of a protest is entirely consistent with what the Proud Boys make it their job to do.
Oh, I see. So the Proud Boys do X. Kyle Rittenhouse did X. Kyle must be a member of the Proud Boys. That's the logic he's using. And this guy actually went to law school. Amazing. By the way, this whole deal of, well, we'll let the jury decide what's relevant and what's not. No, we won't. The whole point of the Sullivan test is not to put prejudicial evidence in front of a jury because they could be swayed by it and give an unfair verdict. Did they not teach you this in law school? You want a fight presented to the jury that shows Kyle hitting a girl so that they can look at Kyle and go, oh, he's a girl beater. Oh, I would love to do something to him. Oh, I know what I could do. I can make him guilty and put him to prison. That's what you want to do. Even though the occurrence that night in Kenosha had nothing to do with that fight. Kids get in fights all the time. Who amongst us has never been in a fist fight? How would you like to be judged on a capital crime later and found guilty because you got in a fight a couple of months prior? None of you out there would want that to happen to you. But you want Kyle to go to prison for life because of it. That's why we don't allow this as evidence.
And then he meets with the leaders afterwards. To me, I think there's a reasonable inference that these are consistent motives all along.
Okay.
Yeah, you want to actually convict people according to proof beyond reasonable doubt, not inferences.
And you've been in here enough, Mr. Krause has been in here enough to know that we get these three sentences where the defendant is accused of any number of things, and there's a section in there about gang membership. And I have stated probably 100 times, probably more than that I don't, I breeze right past that because I'm not interested in these accusations about group responsibility unless it's directly connected that the defendant is active in the criminal enterprises of the organization, or there's kids in neighborhoods right here in Kenosha who join gangs because they're afraid not to. Pope Benedict was a member of the Nazi youth because he had to be. This type of evidence is very dangerous. You make some points that might be legitimate. I certainly would keep the door open if you could show that there's any connection between the defendant on the day in question and this organization. But as I said before, if this organization embraces the defendant after the fact because he's lionized because of his behavior, that is not something that the jury can make anything out of that would be lawful.
All of you anti-Kyles out there, especially the progressives, you should be supporting what the judge is saying here. Just because a person is a member of a gang doesn't make him guilty of a crime just because the gang commits those kinds of crimes. He's being very fair to people who belong to gangs. And guess what? The Proud Boys are being treated here very much like a gang. And so the whole idea is that even if you can prove that Kyle was a member of the Proud Boys and the Proud Boys commit these kinds of offenses, that doesn't mean that Kyle committed those kinds of offenses. And the judge is saying that we have this all the time. I have told you 1 billion times that we don't do these kind of things. And guess what? The defense in their response mentioned it. Why in the hell did you not prepare, Binger? You should have known this was going to come right at you. The defense told you they were going to object to this, and the judge has said many times that this whole thing about gangs and stuff like that is not one that he allows. So how in the hell did you walk into this trial and not be prepared for this? And the reason is very simple. You never prepare. You don't prepare for anything. How many times have you been snowed by somebody bringing up a statute that you hadn't read?
So, as they say, I'll keep the door open a small amount if you've got some evidence to suggest that there was some prior knowledge or awareness, but otherwise, I think the evidence would be poisoned and it would not be allowed. All right, now the next one is but otherwise, I think the evidence would be poisoned and it would not be allowed. All right, now the next one is
All right. Kyle, you got a couple of good lawyers on your side. And Binger, somewhere along the line, you're going to have to gather this thing in. And yeah, I know I heard about this drone thing. Oh, not a drone. It's a fixed wing FBI video. We'll talk about that in another video coming up. I'm taking this thing in pieces. It'll probably be like the third or fourth one. At any rate, like my video, subscribe to my channel, and check out my past videos, especially the ones on Binger's motions, and have a good laugh. They are an absolute joke.